State of Michigan versus John Mitchell, case number 18 FB 1742.
Rachel McDuffie for the people.
Assistant Public Defender Donnie Leopold for Mr. Mitchell.
All right, Mr. Mitchell is supposed to be here. He's supposed to be paying $25. Is that Mr. Mitchell?
Yes, ma'am.
Wow. When did you show up?
I've been on here.
All right.
I've been on here, man.
All right. So, Mr. Mitchell, you're supposed to be paying $25 per month. Have you been making those payments?
I think my fiance said $75, but I called down there. They act like they ain't get it or something.
Yeah, we did not get any money, sir.
No.
Is Miss Fox your fiance?
Yes.
Yes.
Okay, because the reason I know is that's the name that's on the screen, not your name. That's why we didn't know that you were here.
Oh.
All right. Well, sir, you need to figure out how you're going to make your payments.
I'll start. I'll work some, do some odd jobs or something. I'm still looking for a job.
I'll bring you back on October 26th at 10 a.m. to see if you found a job, okay?
Yes, ma'am.
When you come in, make sure you have your name on the screen, not someone else's.
Welcome back to Time Served, the channel that scans the docket so you don't have to. I'm Phil, and do we have a show for you today? We have two updates, 14A and 14B. First up, in 14A, Judge Simpson deals with Mr. Tony Bailey. We all remember Tony Bailey, the one who drew pictures, talks about his piranhas, calls judges by their wrong name. Then when he was in 14B, he called Judge Washington pretty. Well, he's back today in all of his glory, and he wasn't his happy-go-lucky self. I'll show you that clip and show you why. Then we go down the hall to 14B, and you know it's bad when you have so many cases that you just rattle them off and just see which one sticks and which one you're supposed to be in Zoom court for. But that's not even the star of the show. The star of the show is Mr. Andrew Cronin. Do you remember Andrew Cronin? The guy getting caught saying racist things back in July, getting caught hot mics, getting frustrated on everybody's last nerve. Well, here is a short clip of his first appearance back in July.
3 at 9 a.m. Bond will continue.
I feel that I really felt that was ineffective counsel. Am I not allowed to speak or say anything at all as long as I have an attorney? Are you saying that if I have any attorney, whether it's Mr. Smith or anybody else, that I'm not allowed to comment on in my own court case?
Mr. Cronin, that is correct. If you have counsel, then your counsel speaks for you.
Okay, great. Thanks for informing me.
You're welcome.
Oh, doesn't he just give you douche chills? Well, he's back today, and apparently he's been very busy on social media. Prosecutor McDuffie explains to Judge Washington what's been going on since our last case. And why does his attorney mention Trump? Well, you'll find out soon enough. Ask and you shall receive. Backed by popular demand, I've been reading your comments, and everyone seems to love when I scour the backlogs and archives of Judge Boyd to find gems. And yes, I found a good one today. Apparently, there's a rapper in Texas that is motioning the court for more leniency while on probation because he needs to make his appearances and his career. I don't know much about his career. I could care less. But all I know is that Judge Boyd makes a Janet, Michael, and Tito reference. Then we go down to Florida, where one after another, these gentlemen are asking for speedy trials. And by the looks and sounds of them, I don't think Judge Mercer has a problem with getting them in and out as quickly as possible. One even argues with Judge about court time and how long the speedy trial is supposed to be. It is great. Don't forget to hit that like and subscribe, set your notifications to all, and never miss the Daily Docket. Court is now in session. Let's roll, nerds.
This is Cynthia Bond versus Elite Car Care. Can I get appearances on that?
I am here, Your Honor, along with my husband, Leroy Bond.
All right, Miss Bond, can you tell me your name?
Cynthia Bond.
All right, counsel.
Morning, Your Honor. David Gannum for the defendant.
All right, so this is the time and date we set for motion for summary dispositions and just an additional settlement conference. I've reviewed the documents that were submitted by Mr. Gannum, and it's abundantly clear, Ms. Bond, he submitted the warranty that you had on the vehicle, and the warranty is not with Elite Car Care, it's with General Motors. You should have
Your Honor, I disagree. That is a generic warranty that came off the internet. That is not the warranty that should have.
Where is it then, Miss Bond? Where is it then?
Because
I asked everybody to submit it, and this is all I have.
Okay, that is what he got off the internet. That is not the warranty that should have came with the remanufactured engine.
No, ma'am, Miss Bond, with all due respect, I've reviewed it, and the warranty is the 3-year, 100,000-mile warranty.
Okay.
That comes with the vehicle, and it's plain as day. That the warranty was not a special warranty that was given to you by Elite Car Care, but that it was the warranty that came with the car. And you've offered, and Ms. Bond, as the plaintiff in the case, you have the burden of showing that is not true. You have the burden of establishing that there is another warranty. And everything, you submitted nothing, and defendants submitted documentation showing the warranty, and the terms of that warranty are mirror the terms that are listed. What I was so concerned about last time was that the terms that were listed on the documentation from Elite Car Care, it made reference to this warranty, and the terms of that warranty are the same as the terms on the GM warranty. So I understand your position, ma'am, but it's a motion for summary disposition. And and I understand you don't have counsel, the defense counsel does, and I want you to know I've granted you courtesies that I don't entirely know I have the authority to grant you. Matter of fact, I'm fairly certain I don't. But I wanted to grant you the courtesy of having an opportunity to present your case despite counsel. Remind me, Mr. Gannum, were there requests to admit on this case?
It was, Your Honor, and that's part of our.
All right. Yeah, there were requests to admit. And Mr. Gannum, let me just go through this as a courtesy to Ms. Bond. You filed, you were sent requests to admit. Under the court rules, if you don't answer those within the time laid out by the rule, you automatically are deemed to have admitted all of those things that you were asked. And quite frankly, you would have lost on that alone. But I tend to have a belief that requests to admits are an unfair tactic when you have a party that doesn't have an attorney, which is, it doesn't matter what my personal thoughts are on that, Ms. Bond, because ultimately I am to follow the law and the court rules. But so now you have to know me. Ma'am, you have the burden. It is a motion for summary disposition that was filed. The documentation that was provided by counsel, along with the request to admit, clearly shows.
So, Your Honor,
shows that you cannot meet that burden, ma'am. I will give you a moment to talk, but I'm granting the defendant's motion for summary disposition. There is no question of material fact on this case.
Okay, Your Honor, may I speak now?
You may.
Okay, so in the warranty, I did comply with the warranty, and when it states that I have to follow my manual when it came to my oil changes, and I did follow regarding when my oil changes should be. I did submit evidence that I followed the manual when my oil changes should be. There is nothing up in writing when my oil changes were supposed to happen. I put in the oil that's upon my paperwork, what the oil was supposed to be, and in my documentation from my manual that the GM indicated was supposed to happen. They happened when it was supposed to happen. I followed my manual to the letter.
Miss Bond, I respect all of that. I'm not saying you did anything wrong. I'm saying you're suing the wrong party. If you have a warranty issue, you can't take it out on elite.
So Your Honor,
they're a third party that has nothing to do with that. You need to contact General Motors.
So Your Honor, when I go to Bell Tire or when I go to Midas and I get a muffler or a brake job and they tell me that my brakes or my muffler is under warranty, when I have an issue, I go back to them to fix the problem. I don't go back to Midas or to the muffler manufacturer to get that fixed.
I respect that, Ms. Bond, and that might be true, but I'm telling you, there are different types of warranties. You could have a warranty from the Bell Tire, or the tires, Goodrich could have given you a warranty on those tires. So when you go back, if that who and how that warranty is honored is if Bell Tire says we're not fixing them, we think that this doesn't qualify under your warranty, then your responsibility would be to go to whoever gave you the warranty. And in this case, Elite Car Care did not give you the warranty. General Motors did. So if you have a cause of action, the cause of action would be against General Motors. So that is my ruling. I am granting the defendant's motion for summary disposition. Respectfully, the wrong parties involved in this lawsuit, and the case is dismissed.
Your Honor, I'm Mrs. Bond's husband. Can I speak for just a minute?
Yeah, but I have other matters to handle.
Okay, I understand. I'm going to be quick. Okay. My wife she's got a receipt that doesn't even state the engine is from GM. We don't know where the engine came from. We don't know. So how can we call them? And you
can look at the warranty that was given to you in the documents that the defendant just filed.
But we just got the warranty, Your Honor.
Your Honor,
Ms. Bond, Mr. Bond, listen here. I asked you. You had already lost this lawsuit, with all due respect, when you failed to answer the request to admit. But I am trying to clear this up with you. You had already lost, but I wanted to give you the opportunity to produce whatever documentation you had that would support your claim, because I don't like requests to admit.
But how did I fail to do that?
I gave you a month and you brought me nothing, and you've left.
But how did I fail? I submitted everything, Your Honor. So how did I fail to answer the request to submit?
Okay.
And I submitted everything.
And the defendant's motion is granted. Thank you.
May I submit an order through your online?
Okay, we're back. Oh,
there you go. There you go. And is Mr. Williams there?
Yes, ma'am. 1 second.
Okay.
This file 223525 SM, People versus Rondell Lee Williams. Here today for a pretrial conference. Original charge in this case is a charge of assault and battery. I have received a pretrial conference sheet. In the case, the prosecutor's office will reduce this to a charge of disturbing the peace. They have not indicated if we're able to proceed to sentencing. Can you bring the prosecutor back in? So, Mr. Williams, the charge you're pleading guilty to is a reduced charge of disturbing the peace. Disturbing the peace is also a misdemeanor charge. It carries a maximum penalty of 90 days in jail and a $500 fine. Knowing that, do you still wish to plead guilty to the charge of disturbing the peace?
Yeah, disturbing the peace, yeah.
Okay. On June 15th of this year, you signed this advice of right sheet. Before you did that, were you able to read all of that, or did someone read that to you?
I think somebody read it to me.
Those are your trial rights and your appeal rights. If you plead guilty, you will not have a trial, be giving up all those rights that are contained within that sheet, including the right to have your attorney represent you at that trial. Do you understand that?
Yeah.
Has anyone promised you anything as far as what's going to happen to you if you plead guilty today?
I just hope I don't get put in no jail cell.
Okay. Has anyone threatened you to force you to do this?
No.
Is it your choice to do this?
I did one day. What'd you say now? Sir?
Did anyone threaten you to force you to plead guilty today?
No, sir.
Is it your choice to do this?
Yes, sir.
And are you pleading guilty to this charge because you think you're guilty of this charge?
Just plead guilty because I'm not ready for sure. I want to plead.
Well, who is Paul Bedoin, first of all?
Paul Bedoin? That's like I told the other lady. I don't know them. That's why I'm taking the charge. I don't know nothing about that name. I don't.
You don't.
Where is he from?
I have no idea. I just have a name. Is he a staff member at your old residence here in Allegan?
Oh, I never got in fight Allegan.
Okay. Well, Ms. Strasser, I'll need your assistance here.
Okay. I believe that Rondell was another resident at
Rondell is the defendant.
Or sorry, I believe that, let's see here. Yes, Paul was another resident at the AFC home at the time.
So, Mr. Williams, back on December 5th of last year, 2022, it indicates you were living at a residence here in Allegan County. Is that true?
Yeah, I was in Allegan, but yeah, that's true.
Okay, when you were at that residence in Allegan, did you assault someone?
Nah, I put that on. I put that in the level guys. I didn't saw anybody.
All right. Well, did you do anything to disturb the peace?
No, not too much.
Okay.
I stayed to myself most of the time.
Mr. Williams, we're going to have the public. We are going to have the public defender talk to you further. We'll come back to you in a bit after you've had a chance to talk to her. Okay.
Okay.
Okay. Thanks.
Be there, but she has had some trouble providing the sample. She did indicate that the testing facility notified her that there is a way they can do oral testing. I don't know if that's a possibility this court can put in place for her, but she has had some trouble due to a medical condition. She indicates was providing a urine sample.
In order. What I will do is I'll adjourn the probable cause conference to September 14, 2023, 9 a.m. so you can try to get all of that other thing. I will sign an order. Her bond will continue. I'll sign an order allowing oral testing.
Thank you, Your Honor.
All right. Otherwise, bond will continue.
Thank you. Thank you very much, Judge.
Thank you, Your Honor.
Thank you. You're welcome.
Does he have a parent or guardian present?
Yes, I'm finna call her now.
She got to get on Zoom.
Oh, she got to get on Zoom. I don't think she know how to do that. I apologize.
Y'all not in the same building?
No.
Who you calling?
My mother. She's calling now. Here she go.
Ask her if she knows how to get on Zoom.
Ma, you know how to get on Zoom? I said, do you know how to get on Zoom? She said no.
Is she staying in the same city as you?
I didn't hear you, ma'am.
Does she live in the same city that you live in?
She live in the same city I am, yes.
You gonna teach her how to get on Zoom?
Look, Ma, do you got Zoom on your phone?
Probably not. You ought to know how to put that on her phone too. How you letting your mama run around, you not helping her learn how to use the media on the phone?
Ma, you gotta download Zoom.
Mm-hmm. Like she know how to do that.
She do not download.
I know.
Ma.
Where Auntie Shania?
I'm not there.
Tell mama you gonna call her back.
Ma, she said I'm gonna call you back.
Tell her you gonna call her back.
All right.
Now, young man.
I apologize.
You got your mama out there. You gonna? Oh, she know how to download.
I apologize.
If she knew how to download, she'd have done it by now. You just leaving her hanging out there.
I apologize.
Yeah, I'm not the one you need to be apologizing to. You need to be apologizing to your mama. You are not even helping her come into the 21st century. But you want her to help you to get higher. Now, what's going to be easier? Is it going to be easier for the two of y'all to come down to the courthouse? Because if she can't work Zoom, she not with you on Zoom, this not going to go the next time either.
Okay, I was about to say, my sister is here. Will my sister help?
No, your sister is not old enough.
My sister is old enough.
What did I say?
I apologize.
She's old enough for you, but she's not old enough for me. Okay. Now, what's going to be easier? You going to bring your mama down to the courthouse and we're going to do this live and in person?
Yes, I call her and see, yes.
All right, she working?
Yes.
You know how long she needs to have advance notice so she can get the day off?
I was about to say she worked 3 to 12. And yes, I was about to say I can call her and see if when she's free. I know they're supposed to go to Chicago for a family reunion.
When?
On the 26th. On the 25th.
Oh, it won't be that soon.
Oh, okay.
She'll be back by the time I get you in the court date.
Okay.
But that don't mean you going to the family reunion.
Yeah, I know.
Yeah. See there? If you took care of your business, had your mama download the Zoom, we might have been able to talk about that. You got your mom out there hanging. Emma?
Yes, ma'am.
Ooh, we keep touching these files 2 or 3 times. Young man, last time I talked to you, did I told you to go over flip script?
Yes, ma'am.
Did you?
No. I did. Once they called me over the phone, yes. I talked to them over the phone. They was doing video stuff with me, like Zoom stuff like this.
And what were they doing over the Zoom, just like this?
Like therapy. They had this, I forgot her name. It was somebody named Aaron. I guess he was the therapist or whatever. He was talking to me, and then I was talking to him for a few weeks. I guess the evaluation, and then he pulled me over to the psychiatrist, and I talked to her like 3 or 4 times.
You got a GED, high school diploma?
Can you repeat that?
Do you have a GED or a high school diploma?
No, ma'am.
Then you should have been over at Flip working on that.
Correct. I ain't mobile. I'm not driving. And everybody that's driving. Right.
Bus. Right. Otherwise known as public transportation.
Right.
You got a job?
Yes.
Where are you working?
This landscaping.
Of course, you getting a paycheck, right?
Not a paycheck, no.
Mm-hmm. It's under the table?
Yes, ma'am.
So prove you working.
I can do that.
Yeah, I'm not gonna take it.
I really do.
Okay. I know if you went over to flip the script, they could get you a job with benefits.
Can I say something real fast?
Go right ahead.
I about to say it. I can get a job, bitches. I can't stand that long.
They can help you with that. You need to tell them. I need a job where I can sit down periodically or all day long. How you doing landscaping and you can't stand that long?
I take breaks. And it's a riding lawnmower. I don't be standing up. It's a riding lawnmower.
Well, I know you need to be over there, flip the script. What city you living in?
Detroit, Michigan.
When there's no excuse in the world why you haven't been to flip the script. Every bus in this man's town cross Woodward or the Boulevard. Every bus in this man's town. And if you needed bus tickets, all you had to do was tell them. You could have told them that online. They'd have mailed you something.
Right.
Guess what? You coming to me asking for hiders so you don't have no felony record, asking for probation so I don't lock you up, but I can't get nothing from you. You got to give to get. You following me?
Huh? Yes. Yes, ma'am.
You doing landscaping, you need to be over at Flip the Script telling them that. You need a job that pays and got benefits, long-term future, that you can sit on. You need to be telling them that. You got to get your GED, high school diploma. You need to tell them that. You need bus tickets. You need to tell them that. Now, you're not starting off on the right foot with me. And I'm the only judge you got. You still got the number for Flip the Script?
Yes.
Yes, what?
Yes, ma'am.
You still got the address?
No, ma'am.
I'm going to give it to you again. $27 77 East Grand Boulevard.
You said 27
Yeah.
77?
Yes.
East Grand Boulevard.
Grand Boulevard. You're going to bring him and his mama down to the courthouse.
September 25th, Your Honor.
Mr. Dean, good morning. Mr. Dean, you're here for first appearance. You've been accused of one count of loitering or prowling. Mr. Dean, there is probable cause for this charge. I'm going to appoint the public defender's office to represent you, and I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, at this point in time, I spoke to Mr. Dean, and he is not going to plead anything. He's just going to ask for some kind of bond.
Yeah, I actually, Your Honor, excuse me, guys. I want to request a speedy trial be motion for a speedy trial being in the court today. So I got 60 days from now to have a trial date set for that loitering charge.
Yeah, that's not correct. I'm not sure where you got your law degree at, but it's 90 days in Florida when you file the motion for speedy trial, not 60 days on a misdemeanor case. But Mr. Dean, I'm just going to set you a bond today, and we'll see you long before 90 days because you've been to prison 2 or 3 times. 3 times you've been to Department of Corrections. Your bond's going to be $5,000 cash or surety. Your bond has a condition, no contact with the property you're at. If you post the bond, we'll see you at a later court date out of custody. If you don't post the bond, we're going to see you in 3 or 4 weeks at a court date well within your speedy trial time period. Any other questions, Mr. Dean?
You see, I got a $5,000 bond for loitering charge, Your Honor.
Yes, sir. Yes, sir. Yes, sir. Any other questions?
Yes, sir. So you got it on. You got it in the court transcript, right? Just that I request a speedy trial during the first appearance, correct?
It's on the record.
And you stated it's 90 days.
Speedy trial in a misdemeanor case in Florida is 90 days.
Oh, okay. Like I told, I wasn't familiar with misdemeanor case. I just knew felonies is 60 days though. But all right.
Have a good day, sir.
I get on the.
After Mr. Dean, we have from new charge of affray. Mr. Shivers, I've read the complaint. There is probable cause for the charge. You're also out on bond in case 23-279 CF. And in that case, you've got court coming up. Right now, it's set for November 14th as your next court date. Mr. Shivers, I'm going to appoint the Public Defender's Office to represent you in the affray and ask that you listen to Mr. McDaniel.
Judge, we're just going to ask for a reasonable bond.
Mr. Shivers, what I'm going to do is set your bond in the new charge. I'm going to set your bond at $5,000 cash or surety. I'm not going to revoke your bond in the other case at this point because of the circumstances of the new charge, but I am going to hold you until the state can have time to file that motion to revoke bond if they wish, and let that be heard in front of Judge Garcia, who is the judge that you're out on bond in front of. So, Ms. Bremer, how long does the state need to review that and file the motion to see what Judge Garcia wants to do on that?
Your Honor, I've notified ASA Jeffcoat of that. I have not heard back from her yet, but I would anticipate we could do it within a few days. I don't know what the court considers a reasonable time.
All right. So what I'm going to do is this. You've got no bond for 1 week, Mr. Shivers, in that felony case. Ms. Bremer,
I want a fast speedy trial. I want a fast speedy trial within 90 days.
Hang on just a second. One case at a time, okay? One thing at a time. So the reason I'm not going to revoke his bond is because I don't know the circumstances.
I ain't doing nothing. This man was there.
Yeah, you might want to use that mute button, Mr. McDaniel. I don't know what led to the conflict, but I'm not comfortable revoking his bond without having more information on what led to the conflict. If he was acting in self-defense, he allegedly was fighting in the middle of the roadway, but I don't know what happened before then. So I'm not going to revoke his bond, but I'm going to hold him for 1 week and let the state file a motion and let it be heard in front of the judge that has jurisdiction over the case.
Thank you, Judge.
All right. You have any questions, sir?
Go ahead. Hey, Judge.
Yes, sir.
The man hit me. I was trying to go around it. I was trying to leave the situation.
That's why I'm not revoking the bond. The problem, Mr. Shivers, you wouldn't even tell them who the other person was, so they couldn't fully investigate it.
I didn't know his name. Didn't I tell y'all when I got here? Did y'all help me? Can y'all come up here and tell these people this?
Mr. Shivers, I've set your bond. I'm not revoking your bond at this time, but we're going to see what happens in felony court because you've got a pending felony. That's the problem.
I was trying to leave the situation, which I did leave.
All right. Have a good day, sir.
Yeah. I want a fast speedy trial.
All right. So I said 5 and no bond for 7 days.
Bailey, state your name.
Tony Warren Bailey. Good morning, Judge Shelton.
Hey, well, that's okay. That's close. Good morning.
Good morning. Good morning. Good morning. Today is my daughter's birthday. She's turned 32 today. Good morning.
All right.
Remember these piranhas, Your Honor? I brought you a picture of
them. No, I don't, but they look familiar. They look like the other piranhas I'm used to seeing.
Yeah, there's 7 of them that's floating in the tank right now that I got to go home and bury.
Okay. All right. Well, let's
see what we can do. Can I say one more thing, Judge Shelton?
I haven't been able to stop you yet. Go ahead.
Well, I've been here 90 days, Your Honor, and I completed all those other cases. I got them all squashed. Like I say, today is her birthday, and I did add a couple more things to your hot rod if you'd like to see it. The car I drew you last time, there's no bullets on it.
Okay. Okay, well, first of all, let's find out what we're doing on your case. Mr.
Okay,
Minsky.
thank you. Thank you.
Your Honor,
How you doing?
hi, Mr. Bailey. Your Honor, I think what we need to do is set his matters for a preliminary exam.
All right. Then here's what I'll do. Preliminary examination will be set in person September 5th on both cases, 2023, 9 a.m. before Judge Washington. This isn't horrible.
Your Honor, Mr. Bailey is hoping that I address bond.
Go for it.
Thank you very much, Your Honor. Mr. Bailey has been in for 90 days, Judge. I'm sure the court's aware that there was a referral previously, but he is asking that you would allow him to be released on a personal bond at this time, especially given the amount of time he's been in. As he indicated, today is his daughter's birthday. He would very much like to be out so that he can be with his family. Unfortunately, I believe his Social Security was terminated given the amount of time that he has spent in custody. So he's going to need to get that taken care of once he is out, and perhaps, we'll be able to provide him some assistance with that through our social work department. The court's already heard that he does have his piranhas at home that need to be addressed, as well as other matters in his home regarding his utilities. So he would very much ask you to allow him to be released.
Any response?
Your Honor, at this time, we would ask that his bond remain the same until his preliminary exam. Just given the nature of this case and how it's been going, we would just ask that the bond remain the same.
I don't see how that's possible when I've been here 90 days. All my cases are.
How's his is he in touch with CMH at all?
Yes, I am.
Okay, hold on, sir.
He's indicating yes, Judge. I just from what he just indicated, Judge.
Okay, here's what I'm going to do at this juncture. I'll allow it to be brought up certainly before Judge Washington at the preliminary examination, but I'm not going to change the bond at this time until information is provided regarding his contact with CMH. So at this time, bond will continue. Motion for bond reduction at this time is denied, but you can bring it up certainly before Judge Washington. Thank you.
Your Honor, he's hoping to show you his picture today.
Okay. What picture, sir?
So, Your Honor, so you saying that I can't be released on tether or anything?
No, what I am indicating is
I don't understand this. I mean,
okay, just listen.
Okay, I'm listening, Your Honor. I've been here 90 days. All my cases.
No, I know. And what I'm trying to, you got to listen to me. If you're not going to listen to me, I'm done.
Okay, I'm gonna listen.
What I'm indicating is I'm not opposed to releasing you. It's just I need more information about your contact and connection with community mental health.
Mental health.
And that can either be brought to me or it can be brought to Judge Washington for our consideration.
I am confused right now. I only see mental health people here in the jailhouse. They bring me pictures of art. That's it. I don't have a connection in here. Can I explain it? I don't see mental health. I have been cleared through mental health department that I am eligible to stand trial. I don't understand this part about me being slow or anything, or being retarded or anything. I don't have that problem.
Sir, that's not what I'm saying. What I'm saying is I need more information before I'm going to reduce your bond. That's the bottom line.
Mental health department through the jail? Is that what you're saying?
I've indicated it to your attorney. They'll work with you. I think they understand what I'm looking for. And so they'll talk to you about that. Okay?
Thank you, Your Honor.
Thank you.
Your Honor.
What did he mean? What is
Correct.
I'll have to pull it up on my phone. Is that okay?
All right, I give you an opportunity to do that.
Yeah, I've been.
Mr. Cronon, can you please state your name?
Yeah, hey, good morning, everybody. My name is Alexander Cronon.
Thank you. All right, go ahead.
Judge, I think we're just going to leave this on the trial docket at this point. There doesn't seem to be room for resolution.
All right. Ms. McDuffie.
That's correct, Your Honor. The people are ready to proceed in this matter. I also wanted to address bond before we adjourn this hearing. I did send 2 documents to the court. It was yesterday evening. So I just wanted to briefly address those and make a request of the court.
Did you send those to Mr. Smith as well?
Yes.
All right.
I received them late last night. I'm in Iowa with my father. He's in a cancer situation. So I did briefly read those. I asked the prosecutor, I said, if she really wants to talk about bond, she should file a motion and give me an opportunity to respond, not just send it to me. I have nothing but respect for the prosecutor, but I feel a little behind the 8 ball just getting this stuff the night before. One of the messages is from May, and the other one is from 2 weeks ago. So I don't see the urgency in hearing it without a motion formal response. And we're on the.
I'm sorry, go ahead, Mr. Smith.
That's it, Your Honor. That's all I had to say.
To be clear, Your Honor, the request that I'm making of the court is not to change bond conditions. I was going to ask the court, if the court found it appropriate to do so after I put my request on the record, to remind Mr. Cronon of his bond conditions with respect to the content of those. One of those is a supplemental police report that I received, I think this Monday is when I received it, regarding a message that was sent to the victim in this case.
But the problem is,
not to show up to court today. We don't have further information. There's additional search done to determine where the source of that is. So we don't have anything directly tying it to Mr. Cronon at this point. The second piece of information, which pertains to social media posts that Mr. Cronon has up on his Facebook page, where he describes, he speaks about this victim, this case itself, and has a separate link up to it's 300 and some pages of text messages. That should not be any new information to Mr. Smith, because Mr. Smith has shared those same text messages with me prior to today's date. So that's not anything new. However, the request I was going to make of the court is that if the court can see just the screenshot of the content of the messages that Mr. Cronon has posted on his accounts in a public manner where it can be viewed by all, requesting input and support with the position that he takes on this case with respect to evidence that I believe they're planning to present. My request to the court is for right now to just, the world is small, the community is even smaller, and we have a jury to select, essentially. So I would not think that it would be in the best interest of all of us procedurally for potential evidence in this case to be broadcast online. And soliciting input. The content of those text messages also has a series of annotations and commentary where Mr. Cronon has different individuals that he has invited and asked to provide opinions on the correspondence between himself and his victim. I will submit a separate motion in limine with respect to how those items should be treated during trial. But for right now, I'm just asking the court, if the court finds it appropriate to do so, to ask Mr. Cronon not to post information that pertains to this trial, especially with respect to evidence that is planned to be admitted by himself.
Thank you. Response, Mr. Smith, to that request.
My response is the First Amendment allows anybody to, he's not witness tampering. I don't think it's affecting the jury pool. That have made no arguments about that necessarily. Is it something that we all don't like to see? Yeah, but it's a person's right to talk about a case. Even though I don't like the guy, we have an ex-president that does it every day. We don't like it, but it's unfortunately, unless the court feels there's some significant reason to restrict social media in this manner, then I think he should be allowed to do what he did and have it up on his post. But again, I defer to the court.
Thank you, Mr. Smith. As to the first text message, as the prosecutor has indicated, the further investigation needs to be done to be determined whether or not this was related to this case, first of all, and then secondly, whether it can have any connection to Mr. Cronin. I don't know that. I understand that the message says don't show up, but we don't know what that's related to. So we don't know the context or any of that at this point. So I will allow the prosecution to do whatever research they need to do to make those determinations. As to the social media posts, I did review the documentation that was provided. Are you focused, Mr. Cronin?
I am.
Okay, because it did not appear that you were.
I'm sorry. Somebody waved to me. I instinctually waved back just to be polite.
It does not. I agree that, first of all, it does not appear appropriate to be doing that for his own best interest in having a trial with people that are going to be selected from this community's jury pool. However, I don't see where he made any contact with the complaining witness or the victim in this case, and therefore it's not a technical violation of this court's order. But I would caution Mr. Cronin that is not in your best interest to do. As far as social media is concerned and First Amendment rights, when you're within the jurisdiction of the court, the First Amendment rights can be curtailed if it is something that needs to be done in order to protect the efficiency or the interests of the case. And although I don't see it as necessary right now to do that, Mr. Cronin, it is not in your best interest to be doing what you're doing. But I'm not going to tell you not to do it. But anything you post there can and will likely be used against you. So that is your choice to continue down that path, if you so choose.
I don't intend on it.
All right. Having said that, we are scheduled for a jury selection on September 1st. That'll be at 9:00 a.m. And I will see you here then. And at that point in time, as the prosecutor has indicated, there will be more motions in limine regarding these matters. So I created some additional issues for yourself. So we'll see everybody then.
Thank you, Judge. Thank you.
Thank you.
Thank you, Your Honor. And just for the record, I want to say I was never alleging any contact violation. It was just that I wanted the court to essentially speak to the issue as you just did. So thank you, Your Honor.
And sorry for my misunderstanding. Thank you for everybody. Take care.
Thank you.
Okay, so put the time down. 2 p.m. So I will maybe back. Okay. And then we'll just
The court will call the Lawrence Glenn Powers matters, case numbers 21-00438 and 23-00415.
Preaching for the people.
This is both Defender Davi Lebo for Mr. Glenn Powers. Mr. Glenn Powers, could you please unmute and state your name, sir?
Lawrence Glenn Powers.
Thank you. There is a warrant for Mr. Glenn Powers.
Child support?
No, for violating the conditions of the bond.
Not going to community corrections? You said not going to community corrections?
Mr. Glenn Powers, perhaps let the judge finish talking.
So, can I see counsel in the breakout room? There's another one that did not get canceled. All right, we're back on the record in the case of the state of Michigan versus Lawrence Glenn Powers. Case numbers 23-00415 and 21-00438. Is Mr. Lawrence Glenn Powers still here? Yes, he is.
Yes, ma'am.
All right. Thank you so much. All right. As to case number 21-00438, it's my understanding that the people are unable to proceed.
That's correct, Your Honor. I realize that there are bond violations for mistesting in both of these cases, but that's going to become irrelevant because the complaining witness on this matter is not present.
Defense moves to dismiss, Your Honor.
All right. As to this case, that matter is dismissed. based on the fact that the people are unable to proceed. In case number 23-00415.
Your Honor, with respect to this case, the people did not ask the complaining witness to appear at this hearing, and that is due to the fact that this underlying police report and the allegations in this report were not just domestic violence. Mr. Glenn Powers, I believe, was in custody when that warrant was reviewed, and domestic violence was charged as that's what they were able to charge at the time. But there was an underlying cocaine possession issue in that case, and I just received those lab results back very recently. So the people are going to move to dismiss this case because we need to reauthorize that as a felony as it pertains to that drug possession. So that will be happening very shortly.
Based on the prosecutor's motion to dismiss, this matter is dismissed. Well, is there any response from you, Mr. Legal?
Your Honor, there's no response to the new allegations as I've not received or reviewed those. However, we of course do not oppose the motion to dismiss.
Thank you. Case is dismissed. Both matters are dismissed, sir. My understanding there is a warrant for another matter that you probably need to address.
Which is the possession of cocaine that came back. That's the one that came back? Because I was,
No, there is another felony charge arising out of an incident that occurred on August the 8th of 2023.
Yeah, we don't have to fight that too, because I don't know what they're talking about. All right, thank you, ma'am.
David Martin, you're there?
Yep.
You had a chance to speak with Mr. Stevenson on his request?
Yeah, we're not in agreement.
Okay. All right. Let me spotlight everyone. All right, the court is going to call 2021 CR 1804 and 2021 CR 1805, 2020 CR 5024A, 2020 CR 3637. And Mr. Stevenson, the court is aware, I guess the only cases that you filed motions in are the 2021 CR 1804 and 1805. Is that correct?
That is correct. The reason we filed motions in these cases is because these cases have a condition of full house arrest, GPS as condition of bond, and that is the only thing from which we're seeking relief at this point in time, Your Honor.
All right. If I have parties announced for the record, please, for the state.
David Martin.
For the defense.
Ben Stevenson for the defendant. Defendant is with me in my office, and we'll be sharing a device.
All right. We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objections from the defense?
No, Your Honor.
Alexis Morganfield, do you have any objection to us proceeding by video?
No, no, ma'am.
All right. All right. State, have you had a chance to review the defense's motion?
Yes, I have.
All right. State, are you ready to proceed?
Yes.
All right. Defense, it's your motion. You may proceed.
Your Honor, most of the argument that we have at this time is contained within the motion, and I would like to make sure the court is aware that my client has been on electronic monitor full house arrest continuously since March the 3rd of 2021, a period that looks like a period that exceeds 100 days, Your Honor. Now, both of the cases, even though they involve different defendants, both of these cases involve an allegation that the defendant, regardless of circumstances, allowed the 16-year-old complainant to perform fellatio on him at a time when he was 19 years old. There are other details. I'm still getting more information. I have an appointment tomorrow to review a forensic recording on one of these cases, so I'm still assimilating additional discovery. The difficulty is my client has been on house arrest for over 100 days. My client works as a musical performer, and as he performs, he is also an influencer. He provides for himself using those means, but those means do require him to be able to perform at venues and to be able to meet with producers to make deals regarding music and music distribution. The wording of the special condition of bonds does not allow him to go to any of these videos or these producer meetings, which means he is not able to provide for himself at the time being. The other issue is the statement in the special conditions that he may have no contact with any child 17 years of age or younger would prevent him from performing in any public context, because he would not be able to control the age of somebody who might be there as an audience member. And when you really look at the requirement of no contact with any person 17 years of age or younger, that literally would not even allow him to walk into an HEB grocery store, because there's always kids in an HEB. So what we were stating is that the full house arrest is keeping him from working, and the no contact with any person under 17 bars him from just about any public retail place where a minor could be, regardless of any other circumstances. So we're arguing that that is overbroad. In addition, we would direct the court's attention to the records in the possession of Bexar County Pretrial Services showing that my client has been in diligent compliance with these conditions since they were imposed.
All right, State.
Well, obviously, our view of the case is a little different. I wouldn't say that he allowed these two girls to perform fellatio on him. I think there was a little more coercion involved than has been outlined by the defense, but that's kind of our position. We think he should remain on full house arrest. From the reading of the reports, his employment and lifestyle as a producer, influencer, rapper kind of play into meeting these girls and having the sexual assault cases derived from that. He's also got a pending retaliation case against a peace officer, a pending robbery case, 3 misdemeanor theft cases, and an unauthorized use of a motor vehicle that's still awaiting indictment. So for the safety of the community and the fact that he can't keep his hands to himself and keep his hands off other people's bodies and property, we ask that he remain on full house arrest.
May defense respond to one point?
Yes.
The question is not whether there has been an allegation or even a credible allegation raised. The question is, how much of my client's rights need to be restricted, given the fact that we don't know whether he will be convicted of anything when all the dust settles, in order for this honorable court to have peace of mind that this court has maintained the safety of the community. We would argue that if my client wanted to engage in illegal activity while he was on monitor, we would have seen something by now. The fact that we've seen nothing in the last 100 days on a person who's been on bond for a sexual allegation over a year ago suggests that we might have him tied down just a little bit too tight, and that it might be time to at least look at giving him an option to where he can work. If the court does not want him to work as a performer, if the court wants him to drive to a factory and come back, at least the court would be allowing him to support himself and feed himself instead of being a burden on his family. All we're asking is for the court to allow him to show the good faith that he is going to do the right things. He's going to stay away from situations that could be compromising or where people could be tempted to brag that they engaged in more than actually happened. So we're simply asking for the court to allow him to support himself in whatever way the court deems is necessary to give him the chance to show his good faith, and also to make sure that the community is safe. But continuing to keep him locked up after 100+ days of compliance does not seem just. Thank you for considering, Your Honor.
All right, thank you.
And Judge, it's not a sexual assault allegation. It's 2 sexual assault allegations that happen 31 days apart from each other. And in the criminal history, I did fail to mention that he also has a criminal trespass awaiting trial for remaining at a 7-Eleven after he was told to leave. We would also add since he can't listen to instructions and keep from going where he's not supposed to be as part of the safety of the community.
All right, Mr. Stevenson, it's your motion. I'll give you the last word if you have anything else you would like to say.
Your Honor, I've worked with my client over the last year plus, and I've known his dad for quite a few years. My client was hanging around some people who were not making the wisest decisions, and he has since realized that they were not making really good decisions and has stopped hanging around with them. One of these cases is going to involve an allegation that he was hanging around one such individual. My client has stopped hanging around them. He's separated himself from that. If they're making bad decisions, he doesn't have time for that because he wants to do the right thing. He wants to make an honest living, and he doesn't want to victimize anybody. We will be taking these new cases to trial. We will be trying them on the merits. As a rapper influencer, my client has over 42,000 followers on Instagram. And we're definitely going to be looking into the groupies and the crazy aspect of simply being famous or potentially famous. At this point in time, I see a young man who has been on a leash for over 100 days, who would like to feel like a man and be able to work again, feel like a human being, and be able to go work hard and get a paycheck. And,
right, and maybe
whatever conditions are necessary for that to happen, that's all we're asking for the court for is a chance.
All right, and maybe the judge is too old, but I have not heard of your client. Maybe I'm not in the follower world where
Your
people
Honor?
have followers. I haven't heard of him, but
Let me ask a question. Have you ever heard of a performer named Muddy Waters?
yes, I have heard of Muddy Waters.
Muddy
Don't
Waters,
tell me that your client is in the same league as Muddy Waters. Is that what you're about to tell me?
I was going to tell you he's in the same family tree. Muddy Waters was the stage name from McKinley Morganfield.
But here's the thing. I mean, sometimes just because you're in the family tree, no, Brenna, I don't know if I should say this, but I'm going to say it. Tito Jackson is in the same family tree with Jaden and Michael, but I mean, you know, he's Tito.
Well, what we're saying is that my client does have the capacity to
He has the
some
roots
background.
of it.
He has some support.
Okay.
And he's willing to work just as hard as his great uncle to make it because he believes that he has music in his soul and he wants to get it out, Your Honor.
Okay. So here's the issue that the court has, and these are thoughts I have, and maybe somebody can address them that can solve the concerns or the issues that the court has. One, this influencer business that everybody wants to say that's a real job. And I'm coming out of my age and saying, okay, we can say influencing is a job. People don't make things anymore. They get on Instagram and hopefully they get a bunch of followers. But my concern is if he is saying he's an influencer and a musician, there are usually certain things that go with being an influencer and a musician. You get young people around you. So if I were to allow him to work, how do we get around that?
Your Honor,
Does he have any other skills?
I do apologize. Instead of using the word influencer, what I should do is I should refer to endorsements.
Yeah.
My clients, he has a little bit of notoriety, he has a little bit of influence within the music business, and there are persons or companies who are interested in his endorsement, and there's value to that, but that does require performances, it does require being able to record, it does require meetings. Now,
I'm sorry. Go ahead. No, Mr. Stevenson,
if
go
we
ahead.
want to control the environment that he's in, it would be possible if he has trips coming up or meetings or things like that. For instance, a lot of the companies that he's dealing with are in Houston. And if he has trips coming up, if we need to clear those with pretrial services so that they know where he is, we have no problem doing that. We are prepared to document as much as needs to be documented so that everybody connected with the court knows that everything is being done above board. It is a different industry now than it was back in the 70s and 80s, 90s when we were young. It's a much different industry, and it takes a lot different skills and activities to make it, because social networking is a huge thing. And for artists to promote themselves, they can't do it without at least giving a nod to social networking, because that's how it's done nowadays.
Brenda, I don't think Ben just realized what he said. He said 70s, 80s, and 90s when we were young. Is he just talking about himself and David and someone else?
Your Honor, that's why I went as far as 90s, because I assume that I'm older than you. I don't know if I am, and I'm not going to ask.
Oh, I don't mind people asking.
I know I'm old.
It means I'm currently alive, so it's all good. State, what if we were to have where he has to get approval so we'll know where he is? Because my concern is, one, of course, protecting the community, but I also do have a concern of he's not working. He doesn't have any money to support himself.
Well, seeing as how these two, at least one of them, I'll have to go back and reread the other one, but at least one of these allegations happens later in the night. If the court's inclined to do that, we would ask that there be a curfew. I don't know that they'd be recording at 2, 3 o'clock in the morning.
All right, so we're now at a curfew.
Well, I'm still opposed to the GPS.
I know you're opposed,
but if the court's going to do that, we would request a curfew be imposed as well.
Yes. Well, I want him, and I think he should be entitled to earn a living, of course, while protecting the community. And one of the ways for the court to try to do that is by giving a curfew and stating that any work he has to be pre-approved.
Your Honor, may I speak to that briefly?
Yes, yes.
Let's say that my client gets a gig, and let's say that that gig is in Houston. Let's say that that gig ends at 10 o'clock at night. My client's going to be in trouble, because if he drives from Houston to San Antonio and makes it back by 11 or 12, he has just basically gone the speed of an airplane to get here. So that would be somewhat setting him. It's more than nothing.
If someone has
get permission,
if someone has an event, say in Houston, they drive to Houston, and then they have to drive back, then it seems to me that there should be some phone calls to pretrial services.
that would be fine.
And there should be something that shows that someone's on their way back. However, I don't want any hotel rooms and staying at hotels because of the nature of this offense.
We understand you.
And I'm not saying that it is true, but I do realize that people have to make a living. I understand that. And he's an adult. He should be supporting himself.
Yes,
but I hope your client realizes that if there are some issues with this GPS, we're going to be right back here.
I fully understand. He's listening and he does too, Your Honor.
And I think everybody knows when it says no contact with any minor, what that means is you're not talking to them. If you were to perform at a concert, you said groupies or whatever, or people underage, he had better not be talking to them. That's contact.
I understand, Your Honor. That was our concern. Because most people are not in the business of carding somebody before they have a conversation with them. So we want to be reasonable. We want to give the court due, but
here's
we
the
also
thing. Everybody out there knows. I think everybody knows an underage person when they see an underage person. If people don't know an underage person when they see an underage person, then maybe people need to go back and re-educate themselves. Because even if you say someone, they don't look this age, or they look whatever, I think once you talk to them, you could clearly see. But Mr. Morganfield, you better make sure someone is carding somebody, because you cannot be around anyone who is a minor. Do you understand?
I agree.
No, I didn't ask you if you agreed. I asked you if you understood.
Oh, yes, ma'am. Yes, ma'am. I understand.
And I don't know what you're doing with this influencer business, but what I do know is 42,000 followers. Yes, that's great. Not people normally don't have 42,000 followers, but my understanding is that you need to get over 1 million followers to like really have your name out there. Oh, what is that shirt? Why are you pulling on the shirt? That's Louis Armstrong.
Oh, no, this my granddad. This my great uncle Muddy Waters, miss. But it's like this. I'm not worried about no followers. That's coming just because, ma'am. It's like I'm just being
okay. Let's do this. Let's stop using the word like, because I'm finding that teenagers and young people are constantly using the word like. So let's work on not using the word like.
I will have my client work on his grammar. I believe some of that has to do with the neighborhoods in which he grew up, which he did not have a lot of control over.
Nope. I'm going to say no to that, because there are a lot of people who, could you turn the camera back to him? Because I want him to hear me. There are a lot of people who grew up in poor neighborhoods. And I would say this, you know who grew up in poor neighborhoods and didn't have a chance? Slaves. But I guarantee you, if you go back and look at any of the writings of Frederick Douglass, Charlotte Ray, I could go on and on and on. Their writing is some of the best writing that you will ever read. So when young people come to me saying it's the neighborhood I grew up in, last time I checked, public education was free. Now, if you want to go to college, they want to charge you. But my understanding is elementary school, middle school, when I was growing up, it was called junior high, high school, all of that is free. People don't want to take advantage of it. People want to drop out at the 9th grade. People want to hang around whomever they want to hang around. People don't want to work. That's why we end up with people dropping out of school at 9th grade and keep saying the word like and trying to be, in the words of Will Smith, back in my day when I was growing up, trying to be fresh, hip, fat, cool, down with it. They need to stop that. And just so you know, Mr. Morganfield, there is maybe a certain way you talk to your friends, different way you talk to your mom, different way you talk to your grandmother, different way you talk to people when you're doing a contract. Do you understand? I'm sorry? So childish things for you, it's time to set them aside because you have 4 cases. They're all felonies.
Yes, ma'am.
All right. And on 3 of these cases, you could potentially end up in prison for at least 20 years. Do you understand?
Yes, ma'am.
So I'm going to give him a curfew. And if you see that your employment that you have isn't working with your curfew, then you need to get a different job. And you're going to have to influence from your house or from your attorney's office. I'm giving him a curfew of 10 p.m. There still is to be no contact with minors. Prior proof of employment. So if you have someplace you need to be, you need to give that to pretrial services within 24 hours. So you're to notify them within 24 hours.
Yes, ma'am.
Your Honor, I want to make sure I understand. So if he has a performance or something that is going to take him past 10 p.m., that will be considered and approved on a case-by-case basis through pretrial services? Is that what I should assume? Okay.
Yes.
Thank you, Your Honor. And if he doesn't have a performance or any requirements like that, then he needs to be home by 10.
Yes, but
okay.
Any employment, any employment that he has, for example, if he has a job that's for tomorrow at 6 p.m., he needs to get approval from pretrial services stating, I have a job at 6 p.m. This is where it is. This is the hours of the job. This is where I will be. So he still needs pre-approval for everything. You understand?
We understand, and that is fair, Your Honor.
And
this is partial. This is partial for work only. It's not for tracking.
No, it's work.
Right.
Partial
but just
for work.
partial for work only.
Yes.
Okay. So if he doesn't have a gig, there's no curfew because he should be at home.
Yes.
Right. Okay. Because Mr. Stevens said if he doesn't have a job, he has to be home by 10. But that if he doesn't have anywhere to go for his job, he's supposed to be at home.
We understand that as well. Now, if it's a performance or if it is a meeting with executives or something like that, he would simply go through the normal process of giving pretrial services at least a day notice.
Yes.
We understand. We thank you for this opportunity. We may revisit this in the future, but this is very much appreciated today.
Mr. Morganfield, you need to make sure you follow all the court's orders. Do you understand?
Yes, Your Honor, I understand.
Why are you trying to give me attitude? I don't have criminal cases. That's you. I'm not charged with these offenses. That's you. So do we have a problem? I'm sorry. I can't hear you. Do we have a problem?
No, ma'am.
He said 3 times in an inside voice, no, ma'am, Your Honor. I just want to make sure you understood.
Is there anything else?
Nothing further from the defendant, Your Honor.
All right, thank you. And we'll close the record.
May we be excused, Your Honor?
Yes.
And this change, will I be able to get a copy of your order? Can I contact the clerks for a copy of this?
Yes.
Thank you so much, Your Honor. I'm going to sign off. Appreciate your time.
Thank you. You're welcome.